Welcome to this final session on the clinical record. In this last part, we will focus on three essential points. First, the legal consequences that a professional or institution may face when the clinical record is incomplete, erroneous, or poorly managed. We will see how these deficiencies can translate into real legal problems. Second, we will review the recommended practices to ensure that the clinical record fulfills its function, clinically, ethically, and legally. This is fundamental to avoiding risks and promoting quality care. And third, we will discuss a very current topic, the dissolution of the INAI and the transfer of its functions to a new body called Transparency for the People, Transparencia para el Pueblo. We will analyze how this reform affects the access to and protection of clinical data. The goal: understanding these aspects will help us view the clinical record as a living tool, one that protects both the patient and the professional, and which must be handled with the utmost rigor and transparency. A poorly compiled clinical record can lead to very serious legal consequences, both for the healthcare professional and for the institution. Among the possible repercussions are civil liability, when the patient suffers harm attributable to a deficiency in clinical documentation; criminal liability, in cases involving grave omissions, falsification, or alteration of data; administrative sanctions, for failing to comply with sanitary standards and not correctly safeguarding the record; and the impossibility of defense, the extreme difficulty or inability to defend oneself in legal proceedings due to the absence or deficiency of documentary backing. It is crucial that you understand this. An entry that is ambiguous, delayed, or missing can be interpreted as negligence, even if the actual medical care provided was adequate. The conclusion is simple. Documentation in the clinical record is just as crucial as direct patient care. The clinical record is not just an administrative requirement, it is a central tool for medical care, professional ethics, and legal protection. Therefore, there are recommended practices that help us guarantee its quality and utility. 1. Clarity and objectivity. First, the wording must be clear, objective, and free of value judgments. This prevents erroneous interpretations and protects both the patient and the professional. 2. Chronology and timeliness. Second, all records must be made in chronological order and in a timely manner. 3. The prohibition of abbreviations. Third, regarding language use. NOM 004 expressly prohibits the use of abbreviations, even if they are common among medical staff. While in practice, certain standard abbreviations like MG, KG, or MMHG are tolerated, their use in diagnoses, clinical signs, or eponyms can generate serious errors. The correct approach is always to write in full technical medical language without abbreviations. 4. Signatures and electronic systems. Fourth, every note must include the full name, date, time, and signature of the professional in accordance with Section 5.10 of NOM 004. Here, we must clarify a crucial point regarding electronic records. You may use an electronic or digital signature. However, NOM 024, which regulates electronic health record information systems, SIRs, establishes that this signature must be an advanced electronic signature. This is a secure mechanism that guarantees the principle of non-repudiation, meaning the signer cannot deny having signed it. The reality check. Many electronic systems currently in use do not meet this standard and only use simple signatures, username and password, which do not offer the same legal validity. Recommendation. Therefore, for notes that may be required by legal authorities or insurers, it is recommended to sign them with a handwritten, autograph signature, even if they are contained within an electronic record. Fifth, completeness. We must ensure that the record includes all indispensable clinical legal elements, informed consents, progress notes, discharge notes, and any document backing the care provided. Sixth, shared responsibility. Finally, remember that updating the record is a shared responsibility among all professionals participating in patient care. It is not the exclusive task of the treating physician. The bottom line. These practices not only improve care and prevent clinical errors, but they also strengthen the legal defense of the professional and the health establishment. The clinical record must always be available and accessible to those with a legitimate right to consult it, without hindrances or unjustified delays. This entails specific duties. Facilitate the timely delivery of copies to any patient who formally requests them. This implies that every establishment, or physician in private practice, must define the specific mechanisms or processes to make this happen efficiently. Guarantee free and rapid consultation by authorized personnel, especially in emergency situations or to ensure the continuity of care. Implement effective control and traceability mechanisms to know exactly who accesses the record, whether in physical or electronic formats. Prevent loss, duplication, or blocking of access due to administrative reasons. The conclusion is strict. Denying access or placing conditions on the delivery of the clinical record is a direct violation of the right to health and transparency. Confidentiality is a fundamental pillar in the doctor-patient relationship and constitutes a strict ethical and legal obligation. This means that only authorized personnel must have access to the clinical record, and strictly for clinical, administrative, or legal purposes. The disclosure without consent of any medical information is strictly prohibited. The misuse or leakage of clinical data can result in administrative, civil, and criminal sanctions. Confidentiality does not end with the patient's discharge or death. Data protection remains binding for as long as the record is preserved. The bottom line: guaranteeing confidentiality is an essential part of the dignified treatment that every patient has the right to receive. In 2024, a major institutional reform took place. This resulted in the dissolution of the INAI, the National Institute for Transparency, Access to Information, and Personal Data Protection. Its functions were transferred to a new deconcentrated body. This new entity is called Transparencia para el Pueblo, Transparency for the People, and it operates under the Secretariat of Anti-Corruption and Good Governance, Secretaría Anticorrupción y Buen Gobierno. This transition has generated legal and operational uncertainty. This is particularly felt in key areas such as access to clinical records in public institutions, the protection of personal health data, and the processing and resolution of complaints related to the refusal to provide medical information. A critical distinction: although the current regulations remain in force, their application now falls upon this new administrative structure, which is still in the process of consolidation. The challenge: this change poses significant challenges to ensuring that transparency and the protection of medical information remain effective and respected during this new era. The dissolution of the INAI and the transition toward the new body, Transparencia para el Pueblo, have left regulatory and operational gaps. These gaps directly affect the protection of clinical data. Specifically, these voids generate significant risks, such as delays or unjustified refusals regarding access to clinical records in public institutions, a lack of standardized protocols for the proper receipt and processing of information requests, the weakening of accountability mechanisms within the healthcare sector, an increase in legal controversies due to the ambiguity regarding exactly which authority is competent to resolve disputes. The impact: these situations affect the legal certainty of patients, healthcare professionals, and institutions alike, generating a pervasive climate of uncertainty. The dissolution of the INAI has generated uncertainty regarding the continuity and strength of personal health data protection mechanisms. Now, more than ever, the responsibility falls upon us, on the professionals, on the institutions, and on those of us actively participating in the academic and clinical life of the country. Faced with this new scenario, it is indispensable to reinforce best practices. We must assume the duty of protecting clinical data as part of a professional culture committed to the dignity of our patients. Some recommended actions include: establish clear internal protocols to regulate the access, consultation, and delivery of the clinical record. Continuously train staff on confidentiality, access traceability, and the regulatory limits on the use of medical information. Maintain backup mechanisms, especially in electronic systems, to guarantee the integrity and availability of the record. And create internal conflict resolution mechanisms to respond in a timely manner when controversies arise regarding information management. Now, beyond technical actions, it is important to recognize the political and civic impact of this transition. Speaking personally, and grounded in the historical and legal framework that has accompanied the right to information in Mexico since 2002, I consider the dissolution of the INAI to represent a step backward. This autonomous body not only protected personal data, but allowed for the auditing of the government from a citizen's perspective. Replacing it with a body subordinate to the executive branch turns the right to information into a bureaucratic procedure where, paradoxically, one will have to ask the government for permission to supervise its own actions. Nevertheless, as physicians, citizens, and academics, we must act according to current regulations. However, we must do so without failing to point out what this change implies. Citizen vigilance and the strengthening of a culture of transparency remain essential, both in clinical practice and in the exercise of our civil rights. In summary, the protection of clinical data cannot depend solely on the current institutional framework. It must become an ethical commitment that each of us assumes with responsibility and rigor. After analyzing the challenges we face with the dissolution of the INAI and the transfer of its functions, it is necessary to turn our gaze back to what is under our control, our own actions as health professionals. Because beyond institutional changes and regulatory ambiguities, the health professional remains the principal guarantor of clinical information. Your daily conduct determines whether the principles of confidentiality, access, and transparency are fulfilled in practice, or if they are diluted in administrative inertia. Therefore, our key responsibilities are inescapable. Document every aspect of medical care with truthfulness, clarity, and timeliness. Actively protect the confidentiality of clinical data, even when there is no external authority demanding it of us. Ensure that the patient can access their information legitimately and timely without unnecessary barriers. And avoid omissions, duplications, or alterations that compromise clinical safety or legal defense in case of controversy. The clinical record is not just a file, it is an extension of the ethical commitment we have to our patients, their dignity, their safety, and their right to the truth. This is backed by NOM 004 SSA 32012 and the General Health Law. But beyond regulatory compliance, we must recognize that we are talking about a standard of professional conduct that reflects who we are as physicians and as citizens. We conclude this session by remembering that the clinical record is not just another formality, nor a simple administrative requirement. It is, in reality, an extension of the Medical Act. It is a tool that protects both the patient and the professional. To document well is to care, to protect, and to answer with truth and clarity before any clinical or legal situation. However, we must acknowledge an uncomfortable reality. In traditional medical training, students are rarely taught that what is not written does not exist clinically. And this has consequences. Unlike other disciplines, such as law, where students are trained from the start to draft with formality, precision, and legal logic, in medicine, the Medical Act is not typically conceived as a formal act in legal terms. It does not need to be in writing to materialize or have clinical effects. If the doctor doesn't document it, the patient can still improve, the surgery is still performed, and recovery still happens. This logic, while apparently functional, has fostered a culture where writing seems secondary, when, in reality, it is an essential act of professional responsibility and legal guarantee. The cultural problem: during clinical rotations, filling out the record usually falls on lower-ranking personnel, interns, undergraduates, or first-year residents. And even worse, in many hospitals, writing medical notes is used as punishment for errors, omissions, or disciplinary faults. This sends a perverse message to the future doctor. Writing is punishment, treating the patient is valuable, documenting is a waste of time. The consequence: hence, many graduates view filling out the record as a burden, a menial task, or even a humiliation. Upon becoming attending physicians, medicos adscritos, some think, I don't have to do that anymore. Let someone else do it. But we must change this vision, because the clinical record is also your job. It is the technical and legal reflection of what you do. And when you do not create it, you lose control over the clinical history, over the evidence, and over your capacity for defense in the event of a controversy. Recap. We have seen that an incomplete record can have grave consequences. We have seen that there are clear practices to improve quality and security. And we have reflected on how regulatory changes demand we redouble our efforts in transparency. In summary, the clinical record speaks for you when you are no longer in the room, nor in the hospital, nor in the trial. Therefore, it must be clear, truthful, complete, and accessible. Not just to comply with a standard, but because it is part of the dignified treatment your patients deserve, and also part of the respect you deserve as a professional. Final thought: documenting is not punishment. It is a powerful tool of care, of ethics, and of justice.